We have a crazy decision out of the United States District Court for the Central District of California by Judge Josephine Staton. Terrible decision, clearly anti-gun judge, no debate about it. There are countless mistakes in this opinion. I'm just going to hit a couple highlights because I got to get this video out fast because I got to finish off my book, but then I'm going to come back because there's so many mistakes made by this judge. It's absolutely terrible and pathetic. And if this was a law review article, it would be rejected by law students is my guess, and certainly might get you fired if you were an associate at a law firm or any of the law firms I worked at. With that said, let's break down the big mistakes that she made, and then we'll cover the rest in a future video. Right here, right now, we're going to start. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Getting very close to an announcement on the next book. Stay tuned for that shortly. All right, folks, terrible anti-gun decision. This is not a shock. This is a Judge Josephine Staton who has ruled against the Second Amendment repeatedly in the past. Pathetic decision, no good, no redeeming value here. Just clearly, in my opinion, she has a result in mind, which is that you are a peon, you are a subject, you're not allowed to have guns, only the elites can have guns. That, to me, oozes from the pages of this opinion as she basically gives every benefit of the doubt and makes every erroneous mistake in favor of the anti-gunners and the anti-gun arguments that you can possibly make. And she rules, of course, that California's quote-unquote assault weapon ban is constitutional. Now, there's dozens of mistakes in this opinion, and I will cover these, but today I just want to cover the big few mistakes, the obvious ones, including potentially an example of lying by omission by this court, and then I'll hit the highlights here, and then we can have more later, really as a teaching point. Okay, so to begin with, here is a classic example that the anti-gunners like to play with. Now, the good news is I predicted this game that the anti-gun judges were going to play over a year ago, and I wrote the definitive article explaining why it's simply not allowed, and in my view will prevail. I have no doubt it will prevail before the United States Supreme Court if a Supreme Court takes one of these quote-unquote assault weapon cases or AR-15 cases. I have no doubt that my view will 100% prevail at the U.S. Supreme Court, but the games that the lower courts are playing, including Judge Staton, is as follows. As we've talked about before, there's a reference in the Bruen case to what's known as unprecedented societal concerns or dramatic technological changes. Now, what's happened is that's part of a complete sentence, which I'll read to you in a moment. So what happens here is anti-gun judges like Judge Staton take that language that talks about cases that implicate unprecedented societal concerns or dramatic technological changes that allow them to ignore Heller and Bruen and pretend they get to make up the law about the Second Amendment on their own. But the reality is that's not the case. Let me start with what the Bruen case says specifically about this notion of unprecedented technological or societal changes, and then we're going to talk about how the anti-gunners misquote this to try to take away our gun rights. To begin with, this is what the U.S. Supreme Court literally wrote in the Bruen case about how you use historical analogs at the historical portion of the Bruen-Heller methodology of interpreting the Second Amendment. While the historical analogies here, which is in Bruen, and in Heller, which is an arms ban case, are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. So as you can see from that sentence out of Bruen, where they're talking about teaching the lower courts how to apply the historical analog methodology going forward in other cases. But what are those other cases? Those are cases other than Heller and Bruen. Heller, of course, already did the text analysis, and then they shifted the burden to the government, and then they did historical analysis, which you're supposed to do under the methodology of interpreting the Second Amendment, under the Heller-Bruen methodology of interpreting the Second Amendment. The Supreme Court already figured out when, if ever, courts and or the government can ban types of arms. That work was already been done. And it's in other cases, other than arms ban cases, other than Heller, that these notions of unprecedented technological changes or societal changes can be taken into account. But what happens here with Judge Staton is she does not quote the entire sentence. She plays games, whether it's because she's not smart, which I highly doubt, or she doesn't like the whole sentence and is trying to pick and choose and omit the critical part of the sentence that says, in other cases besides Heller, which is the binding Supreme Court precedent. This should cover all arms ban cases, including the Rupp versus Bonta case, which is the one we're talking about right here and right now. She conveniently cuts off that and doesn't quote that. To me, that would get you fired if you did that in a memo in any of the law firms I've worked at, and I've worked at some of the largest, if not the largest law firms in the world. And you would get in huge trouble if you played that game. And if you did this to a judge might even sanction you. That's how bad it is to misquote something like this and try to take it a competitive advantage by omitting critical information that's binding on a court. With that said, that's exactly what this Judge Staton did here. What does Judge Staton actually write? This is what she writes. Bruen contemplated that cases implicating unprecedented societal concerns or dramatic technological concerns may require a more nuanced approach. Okay, what does she omit? She omitted the language, of course, that says, while the historical analogies here and in Heller are relatively simple to draw other cases, right? She omits the references to Heller and other cases because she wants to use this language as an excuse to abandon the Heller in common use test, which she quickly does down below. But let's carry on. Then she goes on to say that mass shootings and these weapons, these AR-15s, these semi-automatic rifles, are somehow examples of technological changes or societal concerns. But that's simply not true. How do we know that? In fact, her own opinion, this is why I wonder if she is that smart, because her own opinion in this Rupp versus Bonta case actually blows up in her metaphorical face on this argument, because if you look on page 2 of her opinion, what does she talk about? She explains that the reason why California enacted this so-called assault weapon ban was because in 1989, a shooter with an AK-47 killed 5 school children and injured 32 others at a school in Stockton, California. Now, here's the key. Think about this for a moment. If you have an IQ that's in 3 digits, which I presume that Judge Staton does. Think about this. In 1989, you have shooters that are engaging in mass shooting, killing 5 school children, and 32 others are shot. Then in 2007, you have the Virginia Tech shooting where, dozens of people are shot at Virginia Tech using semi-automatic handguns and magazines that hold more than 10 rounds. One event occurs in 1989. Of course, there's other shootings, unfortunately, like at Columbine and whatnot. And then another shooting occurs in 2007. Why does this matter? Because these events occurred before the year of our Lord 2008. Why is that important? Because it was in 2008 that the U.S. Supreme Court decided the District of Columbia versus Heller case that's talked all about the fact that you cannot, as a government, ban handguns. Period, full stop. And the reason why they said that is because handguns are in common use by Americans for lawful purposes. They cannot be banned. Now, here's the key. Obviously, in 2008, mass shootings and the use of these technologies in the AK-47s were not unprecedented in 2008 because they had already occurred. Something that's unprecedented is something that has not occurred and never occurred in the past. That's what makes it unprecedented. But in 2008, when the Supreme Court has decided Heller, you had a series of mass shootings before 2008 that the Supreme Court was well aware of, including, as Judge Staton points out, in 1989, you had that shooting in Stockton, California. So you cannot possibly say what she says in this opinion in 2024, that AR-15 semi-automatic rifles and mass shootings are somehow unprecedented societal or technological changes because they were already in existence and had already occurred in 2008 before Heller. None of these things can be unprecedented technological or societal change in 2024 if they were already around in 2008 when the Supreme Court decided the Heller case. But this is exactly what I had predicted when I wrote my Harvard article at the Harvard Journal of Law and Public Policy. And here's some of the observations I'm going to make that you should be aware of, because I pointed this out in the Harvard Journal, and I don't know whether or not the Second Amendment plaintiffs cited to this. They certainly should have cited to my article in this Rupp case and brought it to the judge's attention, but I have no doubt that it would have made no difference with this judge who clearly is anti-gun. And in my opinion, as I read this opinion, she thinks that you don't deserve to protect yourself with guns. Only government does. Again, it just oozes from the pages the elitism. At least that's in my opinion. But here's what I write in the Harvard Journal of Law and Public Policy about this argument that anti-gunners are trying to use this unprecedented change argument to try to get around Heller, which is simply not allowed for a whole host of reasons. Here's what I write. To circumvent Heller, government litigants, their amici, and some lower courts have seized upon a single sentence in Bruen that states that, quote, while the historical analogies here and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Gun control proponents claim that improvements in firearms technology, such as the development of semi-automatic weapons, are dramatic technological changes and that mass shootings are unprecedented societal concerns that did not exist at the founding. According to some courts, these changes and concerns justify bans on so-called assault weapons and what are mislabeled large-capacity magazines. However, in arms ban cases, Heller's in common use constitutional test controls, and there is nothing for the lower courts to do except apply that test to the facts at issue. In other cases, non-arms ban cases, the methodology described in Bruen must be followed to arrive at a test that provides the rule for deciding that case or similar cases. It is only in the second non-arms ban category of cases that unprecedented societal concerns and dramatic technological changes might have some application. But that language is not itself a test, and it is irrelevant in arms ban cases. Powerful language from a handsome YouTuber with great hair. No, I'm just joking. But yes, I point this out in extreme detail in anticipation. And by the way, just to show you how it's impossible for the anti-gunners and these anti-gun judges like Judge Staton to use these kinds of arguments that mass shootings are unprecedented, the argument about handguns and modern weaponry being used for mass shootings came literally up in Heller. It was literally litigated in the case, and the Supreme Court rejected all of that, saying we don't measure constitutional rights by how people can misuse a gun, for example. We only care how about they're lawfully used for protection, because I do not lose my fundamental constitutional rights because some nut job in California does something stupid any more than just because someone defames someone in California causes me to lose my First Amendment rights. That's simply not how it works. But just to give you an example, here are some of the arguments that I quote in my article that shows that the Supreme Court in Heller was well aware of the exact same arguments being made by the anti-gunners today against modern firearms such as AR-15s. While the public policy arguments based on dangerousness that were briefed in Heller cannot be listed comprehensively here, the following are a few examples. Quote, in the recent Virginia Tech shooting, a single student with 2 handguns discharged over 170 rounds in 9 minutes, killing 32 people and wounding 25 more. Next point, when more rounds are fired and guns can be more quickly reloaded, the likelihood of inflicting wounds and the severity of resulting injury increases. The next point here, handguns are also used in an extraordinary percentage of this country's well-publicized shootings, including the large majority of mass shootings. Then it goes on to say that the D.C. Council targeted handguns because they are disproportionately linked to violence or to violent and deadly crime, right? So again, here you see that these are the arguments that were literally briefed before the Supreme Court. The Supreme Court read these arguments, assessed them, and decided the Supreme Court's decision in Heller, which gave rise to that if an arm is in common use, it cannot be banned. So it's impossible, if you're honest, in 2024, for judges like Judge Staton there in California to come out and say that AR-15, semi-automatic rifles, modern firearms, magazines, and so on are somehow unprecedented societal or technological changes, and that mass shootings are something no one contemplated in 2024, when literally before 2008's Heller decision, that is exactly what was not only discussed in the news, it was literally litigated in the legal briefs submitted to the Supreme Court before they decided Heller, and the Supreme Court decided the Heller case, period, full stop, despite all this other stuff that Judge Staton seems to think is relevant to today, decades later. The next major mistake that Judge Staton makes here is, of course, what we've talked about on this channel before. We know the anti-gun judges like to make, which is you try to take the in common use test or the historical part of the interpretation methodology of interpreting the Second Amendment, and you elevate to the text. Just to jog your memory, in Heller and in Bruen, you start with the text of the Second Amendment. If a modern-day gun control law implicates the text of the Second Amendment, the burden shifts to the government to come forth with historical analog laws to somehow justify historically that the modern-day gun control law is something the Founding Fathers would have approved of by virtue of the fact that those laws were enacted by the Founding Fathers and were on the books. The example I'd like to give is, again, if you try to assert the Second Amendment defense to say, I'm allowed to exercise my right to keep and bear arms to engage in cold-blooded murder, well, the Second Amendment's text doesn't specifically talk about cold-blooded murder, but if you look at the laws at the time of the founding, it was pretty clear that no American was allowed to use firearms or any arms for that matter to engage in cold-blooded murder. That was simply not allowed, and that's the example to illustrate the point. So here what happens is what Judge Staton does exactly what I predicted, which is she pretends, which is clearly wrong, that the in common use test, which derives from history, is part of the plain text. Specifically, she says that the Second Amendment plaintiffs bear the burden to show that the arms such as AR-15s and semi-automatic rifles are in common use by Americans today for lawful purposes. And she specifically says in common use today for self-defense. She says that the burden is on the Second Amendment plaintiffs and not on the government. But this is clearly false. And she knows it's false, but she pretends it doesn't. It's not. Because if you look at the Heller case, they define arms as anything that can be used offensively or defensively. Therefore, AR-15s and semi-automatic rifles can be used offensively or defensively. All guns can be used offensively or defensively. So no matter at the textual level, the right of the people to keep their arms obviously encompasses arms. So once you're infringing, which means to hinder or to ban or to destroy the right to keep their arms by denying people a class of any kind of firearms, such as AR-15s, guess what happens? That means it's implicated by the text of the Second Amendment. The burden shifts to the government. And what does the government have to do? The government has to come forward with historical analog laws at the time of the founding to show that those kinds of arms could be banned, and that's simply impossible when you're dealing with magazines that are owned by tens of millions of Americans today. They're clearly in common use. Millions of people own these things. It's not even close. So the way that these anti-gun judges try to get around that is they pretend that the in common use test, which is a historical question or historical constitutional test, is somehow elevated to the plain text. The reason why that's important is because it shifts the burden to the plaintiffs to show that these guns are used in self-defense, but that's not the burden. That's really a historical burden. We know it's a historical burden for two reasons. If you read the Heller case, the in common use test derives from two historical precedents or two historical lines of tradition. One is that Americans would bring their commonly owned guns from their farms and whatnot to militia musters. That's what they were required to bring, guns and ammunition that they used on the farms or they used in their homes, that they used in the cities, whatever. But whatever they privately owned, they were supposed to bring to militia musters, which meant that whatever ordinary Americans commonly owned, that was what they owned, and that's what they brought to militias. You can't ban something that everyone at the time of the founding not only thought you had a right to own, but you had to own for militia purposes. The second thing, of course, is there's this line of authority that says you can ban the carrying of dangerous and conjunctive tests. You got to be both dangerous and unusual. And obviously, if something's in common use, it cannot be unusual and thus cannot meet this test. But both the militia stuff, the militia issues, as well as the in common use / dangerous and unusual, all of this blends in from the historical part of the analysis. There's no textual discussion here. This is part of the history. And if you look at the Heller case, all of this mishigosh, this sort of gestalt of information I've just discussed, falls within the discussion of the history of the Second Amendment and the historical traditions dealing with firearms regulations. So again, when you're dealing with history, guess what happens? It means that the burden of proof is on the government. Now, this judge here, Judge Staton, tries to play a game here by trying to say that the text is informed by history. But all that reference means in the Heller decision is that when you interpret the Second Amendment's text, you have to use the definitions of those words at the time they were adopted in 1791. You can't open up a 2024 dictionary today that was written last week and try to interpret what those words mean. I mean, we now live in a world, for example, it just makes a lot of sense because, the people that adopted the Second Amendment had a particular thing in mind, and therefore you want to look at the dictionary definitions in 1791 to understand what those terms meant, which is exactly what the Supreme Court's talking about. It doesn't mean what Judge Staton says here is you can elevate all this historical working and burn the plaintiffs down. That's simply not how it works because, again, you're simply ignoring the text of the Second Amendment. And the last point here, I'll make it real quick, is Judge Staton makes a point that the relevant time period for assessing history is the 14th Amendment in 1868. I predict this. I also wrote the definitive article. I'll put a link to this down below explaining why the relevant time period is 1791. 3 quick reasons why. Obviously, you want to understand what the people meant. The words of the Bill of Rights in 1791 was adopted. That's what's key. The 14th Amendment in 1868 only did two things. It took the original understanding of the Bill of Rights and applied it to two different groups of people. It applied the 1791 understanding of the Bill of Rights to a new group of Americans, i.e. the freed African-American slaves. And it applied the original understanding of the Bill of Rights to a new group of restricted defendant or restricted government entities, i.e. states and local government. That's all it did. It didn't change the substantive meaning of anything in the Bill of Rights. It just applied it to new people. And beyond that, we know the Supreme Court precedent always says that the Bill of Rights means exactly what it meant when it was adopted by the Americans at the time of the founding. I personally like this example. Several terms ago, the Espinoza versus Montana case dealing with the First Amendment's religious clauses. In that case, an opinion by Chief Justice John Roberts, he specifically talked about how when there were 30 state laws, I repeat, 30 state laws after the Civil War, after the adoption of the 14th Amendment that restricted First Amendment religious freedom, okay? Guess what Chief Justice John Roberts in the Supreme Court said in the Espinoza versus Montana case? They said the fact that there were 30 statewide laws that restricted the text of the First Amendment after the Civil War has no meaning, no bearing, no restriction whatsoever on the original understanding of the First Amendment. And because those laws in the late 19th century were contradictory, undercut the text of the First Amendment, they could be completely disregarded. So too, that's the case with any late 19th century laws that are inconsistent with the text of the Second Amendment. Again, the only time late 19th century laws can be relevant to the meaning of the Second Amendment is as a confirmatory or affirmatory analytic. What I mean by that is if you can find evidence in the late 19th century that confirms or reaffirms the 1791 understanding of the Second Amendment, that is allowed, but it is a one-way ratchet toward freedom. It is a one-way ratchet toward the text of the Second Amendment. If the history in the late 19th century, after the Civil War, after the adoption of the 14th Amendment, is inconsistent with the 1791 understanding of the Second Amendment or the text of the Second Amendment in 1791, obviously, the text prevails. That is clearly the Supreme Court precedent, clearly what the Supreme Court has taught over and over and over again, but Judge Staton here clearly refuses to follow that. So anyway, these are the big issues that the judge aired in. There are countless others. I will do some more videos down the road because I think this is a good teaching moment because some people are put on this earth to teach us what not to do. They are put on this earth to teach us what not to become. And I think Judge Josephine Staton is exactly one of these people that has been given to us in the Second Amendment community so we can learn what not to do, what mistakes not to engage in, and what not to grow up and become. I think that's the lesson here, and we'll talk more about this decision. All right, folks, so those are the highlights or the lowlights of Judge Staton's opinions, a pathetic attempt. She clearly doesn't want you to have guns. She's going to write anything at all to make sure you don't get your guns. That's pretty clear to me. So there was no way to win this case in front of her. It was just a waste of time, which goes back to my general theory. When you're in front of a nutty anti-gun judge, your only goal is to lose as fast as possible to get to the appellate courts. That's just the reality of litigation strategy as I see it right now. All right, hope you learned something here about the Second Amendment. And don't forget to subscribe and resubscribe. We're trying to get to 150,000 subscribers on this YouTube channel. And of course, make sure you follow me on X at 4Boxes Diner. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.